Part 5 of the Proceeds of Crime Act is, as you may know, civil recovery. And Section 240 of the Proceeds of Crime Act enables the recovery in civil proceedings of property which is or represents property obtained through unlawful conduct. And the court needs to be satisfied on the balance of probabilities that the conduct represents unlawful conduct. I'll go no further than there in the sections. Safe to say that this, and do not underestimate the capacity and the inclination of SOCA to deal with more and more cases of this nature over the coming years. They are getting, to be fair to them, a lot more adept at using the civil recovery procedures. There was a time when they were quite bad at it. There was a time when it was only actually undertaken by a very limited number of people within SOCA. Now it is much more widespread. Now they have developed a protocol. Now they have an objective. They have the objective of the NCA. They have these pilot schemes behind them. They have, say, better resources, but they are much, much better organised now to deal with civil recovery. But one of the big issues for civil recovery is this extra-jurisdictional problem. But it was resolved in fairly short order by the admin court now in a case that I've dealt with in the material, the case of the Serious Organised Crime Agency v. Perry. And so the answer to the question is a very simple and straightforward yes. The reasons why are in the pack, but when you ask yourself why the Proceeds of Crime Act was enacted, could it ever have been any other question, bearing in mind what the UK government are trying to achieve? But it was a very good example of how SOCA stepped in to seize assets under the civil recovery provisions when, as it happened in this case, Israel decided to convict someone of some very serious money laundering offences, but didn't actually seek to recover the proceeds. SOCA found about £14 million worth of those proceeds in 2 bank accounts in London and decided to do what the Israelis hadn't done in the first place. But they didn't stop there. They went abroad and Perry complained that had to make a concession in terms of the property within the UK, but didn't want to in respect to the property abroad. That isn't a barrier now. Perry's not the only case that deals with it, but it deals with it quite neatly, as you'll see in the material. And that is an incentive to SOCA to deal with more and more assets abroad.